Hi, my name is Biill, and welcome to our video series on legal issues affecting your business. As you can see, I'm giving this video from my home and I hope everyone is staying safe. Thank you for watching and thank you for giving me a reason to put a suit on for the first time in a few weeks. Today I want to talk to you about the COVID Temporary Measures Bill that was read in Parliament yesterday and will come into effect in Singapore later this month. Now, the purpose of the bill really is to give breathing space to certain targeted and relevant industries, events, tourism, landlord tenants, construction and some hire purchase agreements, as well as loans towards SMEs. The spirit of the Act must always be remembered. It is to give breathing space to companies and it must not be abused for parties that are unwilling to pay or unable to pay for reasons that have nothing to do with COVID. Now, there are three aspects of the bill that I want to talk about. And the first aspect is something what I call the moratorium or the suspension effect. There are 5 points I'd like to make. Let's start with the effect. Now, let's look at the end result first. The effect of this act is to prevent parties from enforcing their rights under relevant contracts for the period of the act, which for now is stated to be 6 months, but may be extended. Number two, the application of the Act. The application is targeted on specific industries as mentioned before. Tourism, events, landlord-tenant issues, construction and performance bonds, and more importantly, it's also worth bearing in mind that it also applies to guarantors and sureties involved in these contracts as well. The third point I'd like to make is timing. Now, it's a very narrow window that the Act applies to. It doesn't apply to contracts after 25th of March. It applies to obligations that have accrued from 1st February 2020, which presumably would be the time that the impact of COVID was felt throughout the world. The fourth point has to do with threshold. The language used in the Act says inability to perform due to a COVID event. Now, a COVID event is defined quite broadly to cover, in the first instance, the direct epidemic and pandemic that we see all around us, but also, importantly, to cover acts or orders by the Singapore government or other governments arising from the COVID situation. Things like port closures and lockdowns, I presume, would be covered. The last point I'd like to make on this aspect would be notification. Now, if your contract is affected, then notification is required to be given to the other party. If the other party agrees to it, that's fine. If the other party does not agree that the Act applies, then an assessor is appointed under the Act to decide whether issues have been applicable under the Act. I'd like to make some comments on this aspect. Number one, your contract must be the ones defined under the Act. Now, to my friends in the trading business, I know you see the word supply contracts over there, but please bear in mind that supply contracts mean contracts for the supply of goods to a construction site and not trading of goods. The second point I want to make is timing. If obligations have fallen due before 1st of February, which we have seen in a lot of cases, then the Act clearly doesn't apply to that situation. The third point I want to raise would then be this issue of deciding causation, whether your inability to perform has been caused by the COVID event. Now, this is left, if it's disputed, it's left to the assessor to decide. The assessor's decision is final and non-appealable, but I want to highlight that this is a difficult issue factually to resolve. The second aspect of the Act that I'd like to talk about has to do with substantive defenses under the construction industry. The construction industry is valued at $33 billion as of last year, and the Act now provides two substantive defenses for parties involved in the construction industry. First, it has to do with answer to delay. Liquidated damages payable from 1st February 2020, if applicable under the Act, will no longer be enforceable. Parties will not have to pay liquidated damages or other damages as a result of delay arising from COVID-19. The second aspect is that substantively, the Act provides for defense to breach of contract because arising from the COVID-19 situation. The final aspect of the Act that I'd like to talk about has to do with timelines for starting insolvency, bankruptcy, and similar proceedings. Now, under our existing legislation, the most common way of starting bankruptcy or winding up proceedings would be by way of a statutory demand. A statutory demand can be issued for claims of $10,000 for individuals and for claims of $15,000 for companies. That's the existing legislation. Statutory demand that remains unanswered for 3 weeks, for 21 days, gives a presumption of an inability to pay, which is then a precursor to liquidation or winding up proceedings. The Act changes this. The Act gives more time to parties to comply with this. And it's quite a significant change, both in terms of threshold, but also in terms of timing as well. So the monetary threshold has moved from $10,000 to $60,000 for individuals and $15,000 to $100,000 for companies. More importantly, the timing from 21 days has moved to 6 months, which is actually the prescribed period under the Act. I hope you found these comments useful. It is a new piece of legislation that is coming through. I think there will be many questions that will be raised and many issues that hopefully the government will address as we go along. Please feel free to leave any questions you have or any comments in the boxes below. Thank you, stay safe and have a good day.